Next, we have David Abney, who's going to talk to us about subrogation and updates in ERISA law.
Oh, yeah, absolutely. How's everyone doing? Yeah? Hopefully you've had a couple of glasses of wine, and, the 7:30 show is completely different from the 9:30 show, so feel free to get involved in heckle and all those sorts of things. Nothing better than getting towards the end of the night and have an exciting topic like ERISA subrogation, right? For all the lawyers who handle that, it's usually a topic that doesn't get a lot of credibility for being entertaining, but we're going to do the best we can with what we've got here. So I don't know where we are with the PowerPoint, Amy. Could maybe somebody help me get that up? We'll get that up in a minute. So Amy asked me here because in a lot of ways she wants this conference to be about innovation, new ideas. And one of the things that I want to share with you is something new and different that we've done in the ERISA healthcare subrogation resolution universe. And for a lot of times, lawyers have simply, when met with a self-funded ERISA qualified plan who's asserting a claim for subrogation reimbursement, they've just simply said, oh, okay, well, it's self-funded and ERISA qualified. There's not really much I can do. And what we are doing now in that space is really attacking that presumption because there are some things you can do. This is a particular case that we have been involved in, that we've got some recent success, and it involves a self-funded ERISA qualified plan that falls in the category of what we call a VEBA plan. It's a voluntary employee benefit plan. And it was set up about 13 years ago. Goodyear started rating its pension plans. If you remember, leading up to the financial crisis in 2008, a lot of companies in 2005, 6, and 7 were having financial distress. And one of the ways they looked at getting out of those economic distressful situations was looking at all the money that they had parked in pension plans. That was a really big asset that wasn't potentially being used. And so a lot of these larger companies started rating that money. And in this Goodyear case, what happened is they started rating the retirees, Goodyear, Dunlap, these were steelworker union members. And as a result of that, a big batch of litigation broke out. And so there was a settlement about 12 years ago in the Reddington case. And basically, the union and the retirees sued Goodyear. They reached a settlement that was overseen by a federal court. The Department of Labor was involved. And as part of the terms of the settlement, Goodyear agreed to pay $1 billion to a 9-person committee that would then provide these health benefits for Goodyear and Dunlap retirees presently, and for folks who would come to retire in the future. The reason they set it up as a VEBA trust is so that Goodyear could dollar for dollar take immediately the tax benefit of the $1 billion they used to pre-fund it. In addition, the health plan could invest the money and not have to pay tax on any gains they made in the market. So there was a tremendous amount of focus on this new vehicle called a VEBA trust because of those tax incentives. It is entirely possible to be both a VEBA plan and an ERISA plan, hypothetically. But as we're going to show you a little bit here, that was the issue in this particular case. So about 3 years ago, Pam Steely, maybe on a night like this, goes out with her friends to a country club and they get smashed, drunk. They decided it'd be, fun to hop in a golf cart, and they do, and they flip it. And Pam gets hurt pretty badly. She's got about $1 million in medical expenses, about $475,000 in paid claims. And she hires a lawyer, John Wright, out of Cleveland, good lawyer, and he represents her. But it's a tough case. You got liability, you've got alcohol, they're the ones who flipped the cart. But they do have a premises claim against the country club, over-serving, or a couple of different things going on. So leading up to the mediation, John Wright's doing his due diligence, and he's contacted the health plan and their subrogation vendor. They're in communications, and the vendor leads John Wright to believe, as he goes into mediation, if you settle a case for less than the amount we paid, we'll do a 3-way split. right? Who here practices tort law, right? Anybody left? We got any one? We got one guy left. So this is for you. At any rate, a three-way split is sort of how you're going to handle that situation most of the time. Like, it's pretty common practice. A third goes to the lawyer, a third will go to the client, and a third will go back to the health plan. So John Wright goes into mediation thinking he's got this deal, and he settles the case for less than they paid. Comes out of mediation, calls a subro vendor. She says, yeah, I'm going to recommend that to my client. They just have this, sort of complicated sign off. But, again, I don't see a problem. The money comes in quickly, though. So he takes his third, he gives a client a third, and he parks a third for the health plan. Unfortunately, about 3 weeks later, the vendor calls back and says, they don't want the 145. They want 300, which is now going to be problematic. So John and this subro vendor kind of get into a fight. The subro vendor Goodyear hires an outside lawyer. He then starts to threaten the lawyer. Model Rule 1.15 says a lawyer shouldn't disperse funds to which his client and a third party have a valid claim. So there's that. At this point, John gets me involved in the case. And I say, yeah, I've seen this Goodyear plan before. It's a little wonky. It's a little different. But at the end of the day, I know the lawyer on the other side. Maybe I can get him to agree to the deal. And I try, but can't. And for whatever reason, the lawyer representing Goodyear is really insistent that they're upset that John Wright dispersed the funds. So when they find out about it, they get really mad and immediately sue John. Well, actually, they sue John's firm, stating that they unethically dispersed the money, asking the court to disgorge them of their fee, which is pretty extreme. And then they also sue Pam, and they want all the money. So instead of now the $300 they're asking for, they now want all the settlement proceeds. So I get involved, and I decide that I don't like this VEBA trust because there's something about it that just doesn't stick with me the way that it should. So here's what we find. If I can get it to, maybe. Is it moving? Yeah, I think it's frozen. At any rate, I don't like it. So we pull the trust documents, and lo and behold, here's what we find out under ERISA. Under ERISA, to establish a health plan, it has to be established by one of three entities. An employer can do it. An employee association can do it. That's a union. Or an employee's beneficiary association can do it. And that's essentially a group of employees, but they don't negotiate with the employer. It's just a designation that it simply exists for employers to band together and put together health plans, pension plans, other sorts of benefits. So Goodyear says they're this third category. They're an employee's beneficiary association. As it turns out, however, the DOL definition for that insists that all members have to be of a common employer. And unfortunately, this committee that established the plan, in their wisdom, they insisted that 4 of the members be members of the public. So they could have no connection to Goodyear or the union. In other words, making it impossible for this committee to meet the definition under ERISA. Okay? So in their complaint, the committee established the plan, the committee maintains the plan, but the committee can't meet the definition of an employee's beneficiary association under ERISA because they stuck 4 public members on it. Okay? So I identify this, and I try to talk the other lawyer into just taking his $145,000. We still got it. Seriously. Just take it. Get the case over with. This could be bad. Because if I win and you're not an ERISA plan, the $1 billion sitting in your trust account is going to be really problematic. Because now you've got beneficiaries in 45 different jurisdictions that are maintained by each different Department of Insurance because you don't have ERISA preemption. Not to mention every dollar you collected for subrogation and reimbursement over the past 12 years, you collected fraudulently if you used ERISA preemption as a basis for defeating a made whole rule or a common fund rule or whatever. And since we know that they wanted $300 out of a $450,000 settlement, they probably have been pretty aggressive in using that preemption. The lawyer on the other side literally laughs at me. And he's like, you might be an okay lawyer, David, but there's no way you're going to convince a federal judge to strip ERISA status from a $1 billion health plan. But that's exactly what happened. And we got a ruling on December 31st from the Northern District of Ohio that said, yeah, they're just not an ERISA plan. And the way it worked out procedurally is we made a motion to dismiss because it's not ERISA, so exclusive jurisdiction in federal court based on that. And so we've got the case dismissed. About 2 weeks later, I get a call from Paul Green, who's a named partner in a white shoe law firm in DC, who represents every single multi-employer plan across the country. And his organization is now concerned that my ruling impacts every VEBA plan in the country, about 6,500 of which filed tax returns last year. Because in the process of setting up these plans, they were really focused on the tax benefits and not ERISA compliance. At which point I told Mr. Green that I was very flattered. And that even though I was just some, hayseed lawyer, solo practitioner from Kentucky, that he was right and that his membership was right to be concerned. Because once we did what we did to Goodyear and clawed back all the money we could, potentially even the premiums they collected over the years for, holding themselves out to be a health plan, when in fact, if they're not ERISA and they're not registered with the Department of Insurance in Ohio, I think now they're unlicensed and unlawfully operating as a health plan. That, after we were done with them, we were going to go after the rest. And that's exactly what we're getting ready to do. The point is, when I talk about this case, I talk about it in it's the old saying, you guys may not have it here, but you may. Pigs get fat, but hogs get slaughtered, right? It is okay. It is okay to get fat. But when you get too greedy, the most greedy is the one that gets slaughtered. It's also a really interesting instance in which I think the perception that plaintiffs can't ever win ERISA cases is one that has probably prevented a lot of cases from being tried that should have been tried, or a lot of arguments from being made that should have been made. In hearing the other speakers tonight talk about, there are cases, he was going to try that case no matter what. No matter what they offered, he was going to try that case. And the attitude that we've got to do more in this area, I think, is something that I would like to change the perception of. It's not going to be in every case. And when your back's against the wall, you can come up with innovative and new things. But in this particular situation, I think there's a lot of these out there, and they have run roughshod over plaintiffs and beneficiaries for a really long time. So I don't know if there's really any more slides to go through. But one of the things that we look at this is what I wanted to say. So here's what I love about this case. We had a great judge. We had a really good judge. She had a super high dismissal rate. We sort of targeted that going in. We wrote a 6-page brief on a motion to dismiss, which is not extensive at all. And we just simply put it to her in one way. Judge, you've only got to answer one question. If that committee meets this definition, then let the case go forward. But if it doesn't, dismiss it. That's all you've got to do. And that's what she did. Now they filed a motion to alter a Rule 59. Did you know Rule 59 actually existed, right? Okay, so 59, Rules of Civil Procedure. It's a motion to alter my order of dismissal. Now, they're not saying she made a spelling error, right? Or that somehow there's something that needs to be cleaned up in that regard. What they're really doing is they're making a motion to reconsider. They're trying to get a second bite of the apple. And I told you about my friend Paul Green, who called. Well, the reason he was calling was he wanted my permission to file an amicus brief at the district court level in my case. If that tells you if they're really concerned or not concerned about the impact of this. There are two ways in which he can file an amicus brief. One is if he gets consent of both parties. So now you know why he was calling. I wasn't dumb enough to agree. The other is you have to file a motion for leave. But like we all know, in the motion to leave, we'd like leave to file the attached amicus brief, right? So they're going to get it in front of the judge no matter what. And they did. So, but there has to be some sort of additional filing for them to be able to attach it to in support of. So they have to file this Rule 59 motion to alter although really it's a motion for reconsideration. And as you can see from the standing order in my court, this is what it says. The federal rules make no provision for motions for reconsideration. And although these are discouraged by the court, I love this language. Although in appropriate circumstances, a motion for reconsideration might be warranted, parties and counsel are reminded that such a motion is neither a substitute for appeal nor an opportunity for an unhappy litigant to re-argue their case or to insert arguments inexplicably omitted in earlier motions. Parties or counsel who file unfounded, unmerited, and unsuccessful motions for reconsideration simply because they disagree with a ruling, decision, or order should expect to be sanctioned to the full extent permitted under Rule 11. That's in my judge's standing order. You talk about having the right judge for the right case. Now, she hasn't quite ruled on it yet, but we feel like we're in a pretty strong position, being that she wrote about a 12-page opinion, and they've literally done nothing but re-argue and now brought in a third party to file an amicus brief to raise new arguments. So we're feeling pretty strong about that part of it. Obviously, we're going to go to the Sixth Circuit. And one of the funny things about that is I was really, really concerned, like, oh, they're going to go get King and Spalding, they're going to get Jones Day, they're going to get, and they're going to bury me, this guy who, hayseed lawyer from Kentucky, right? And so I happen to be really good friends with Peter Striss, who's one of the best appellate lawyers in the country, and he and I have worked on a couple of ERISA cases. He argued Montanil in front of the Supreme Court, which is an ERISA case. And so I call Peter and I'm like, man, you're going to love this case. And he goes, oh, no, I do. I love your case. I said, so you'll handle it, the Sixth Circuit? And he goes, oh, David, I haven't handled a flat fee Court of Appeals level case for less than $700,000 in over 5 years. You talk about being in the wrong line of work, right? And I'm like, oh, well, that stinks. But I've got an associate who doesn't have much experience. How much money you got? I'm like, well, we got $145,000. I got to make something. We might have to pay him back something under Ohio state law. And so we agree to put them on retainer. John Stokes, Harvard undergrad, magna cum laude in linguistics, Yale Law School, on the Journal, has co-authored 10 briefs to the Supreme Court, and he's going to handle it on the condition he can argue in front of the Sixth Circuit, which made me a little sad, but it's okay. And they're going to do it for $50,000. So when Mr. Green called me, trying to get a size of the situation of just how much of a hayseed he was dealing, I got to tell him that I just put in the mail earlier that day the retainer check to my good friend and probably the best ERISA appellate lawyer in the country, Peter Striss, which gave me an opportunity to tell Mr. Green that I was ready for him and whatever they were bringing. So it's a fun case, but really what it is, when you talk about being innovative and when you talk about taking a look, there's always a reason to take a second look at an issue that everybody just thinks is a pain. No one wants to understand ERISA subrogation reimbursement. It's been difficult. Historically, it has been very, very difficult for plaintiffs to be successful. But I do believe the lawyer has a good faith obligation, and best practices are, when you're dealing with large liens, just taking the word for it that they're a self-funded ERISA qualified plan is not enough. There needs to be an added level of inquiry, especially when you're talking about anything 6 figures or more that they're asking to be paid. I think lawyers have an obligation not to dissipate those funds improperly. At the same time, they've got an obligation under 1.15 to make sure that they recognize if there's a valid claim. And it's a tough call, and it's only getting tougher. And whether it be someone like my firm or there are a lot of other firms who do it, if maximizing the client's net recovery is the value, and the plaintiff's lawyer does that by increasing the amount recovered from the tortfeasor, what we do is maximize that by decreasing the amount of that settlement that goes back to the health plan. And at the end of the day, that's the goal, to maximize when that client gets up from the table, how much they walk away with, to make sure that those funds can last them as long as they can. And I think this is something that over the past decade, I've seen more and more lawyers just sort of roll their eyes, or there's no way around it, or they don't want to dig into it. But I think that this is such a rich area and potential for litigation. And so if you get one of these cases and you get a VIBA plan, they're almost certainly going to involve a union. They're almost certainly going to involve a client who's a retiree, and they're going to be a retiree of a company that's probably big enough to have that. When I asked Mr. Green how big his association was, I said, so, what are we talking about, Paul? Your folks, what do you got, $750 billion in assets? Is it $1 trillion? And he went, it's a lot, right? So just the one Goodyear plan had $1 billion, 25,000 participants. The largest one out there is about 60 billion in assets. So if you've got a client, especially a client that is retired, there's a good chance they may have and participate in one of these plans. So call me because we're looking for them. With that, I will tell you, I really appreciate the opportunity to come. I think it's awesome. The speakers tonight were great, and just to be included is an honor. And so thanks to Exigent and Amy for having me up here.